To the Supreme Court, where the Council of Governors is tabling a case, and Silas Apollo is there with us, if you could listen in.
All parties, if any, inviting them to attend the court for directions on the mode and date of hearing. And Rule 4, my lords, provides that the court may, on giving the parties an opportunity to be heard, reject, and then it goes on. In the practice directions, my Lord Chief Justice issued last year, it provides as follows at paragraph 31, under paragraph F, that in addition to Rule 41, a party seeking an advisory opinion shall file a reference which shall set out, and then you provide the requirements, those standards for now. And paragraph 32, it says all parties served with a reference in accordance with the Rule 41 shall, within 7 days, notify the court in writing of their willingness or otherwise to be enjoined in the reference. And 33 is where the discretion of the court comes in and says the court reserves the discretion to accept or decline a party's notice of its participation in the reference. So, my Lord, under this practice directions, I'm aware of your ruling in the 2011 Supreme Court advisory reference, but that was before the rules were promulgated. Under the new guidelines, we appear before the Deputy Registrar, and he directs the notice on who shall be served. That happened when we came under certificate. We appeared before the Honourable Deputy Registrar, and he indicated we should serve the parties that we had indicated we intended to serve with the notice, with the advisory reference. And a notice was duly issued to all the parties, because he requested, when we appeared ex parte, who did we intend to serve with the reference, and I indicated the parties who are before you, starting with the National Assembly, the Speaker of the Senate, the Honourable Attorney General, the National Treasury, Katiba Institute, as well as the County Assemblies Forum and the Law Society of Kenya. He gave the directions that we should serve them with the advisory reference, and a notice to that effect was issued, and they appeared before the Honourable Chief Justice the Friday after our first appearance. So, my Lord Chief Justice, under these rules, all we are required to do is indicate at the time of filing who we intend to serve, and the Deputy Registrar, upon looking at the reference, is to give directions on who should be served with a notice. And if any party feels that they should be excluded, unlike the direction that was given in 2011 in your first advisory reference, before these rules were promulgated, then any party who does not wish to participate in the proceedings is to seek the directions of the court and be excluded.
Very well, Thank you. The practice directions you have just read, yes, does not admit the parties, even with the order of the direction of the Deputy Registrar.
Yes, Lord.
So it is the court which admits the parties.
I stand guided, Lord.
Very well. So now we want to start with one of the applicants we notice.
Yes.
Is the Council of
County Governors. Yes. The Council of County Governors, yes.
Yes, Council of County Governors.
Yes. Or in short, Council of Governors.
Yes.
Yes, my Lord.
You have named them as one of the applicants.
Yes, it is the first applicant. Read the reference.
Yes. And you know that there is a pending matter on whether or not the Council of Governors is a state organ.
Before your Lordships?
Yes.
Yes, Lord.
It is pending judgment of the court.
It's a ruling or a judgment?
Ruling.
Yes. Yes.
So we can't have them on record addressing us before we resolve that issue.
I hear you, my Lord. But if... Sorry. Yes, good one, my Lord.
You read the first applicant. Let's say serves in a medical application. Because we have that matter training.
Yes, my Lord.
And there's a beginner of judgment as to whether they take over or not. Especially what is like. Now, for them to come here,
yes, my Lord,
and they know that they important in Muslim. So they have come here
Yes, my Lord.
And in that places a challenge. Fortunately,
Yes.
it's not judicial or coming, cannot come.
Yes, my Lord.
Fortunately, all the 7,000
Before you, my
who are
Lord.
members of the court
Yes.
are so all this request is taken step aside. And for 7
Well, for purposes of this proceedings, we have 48 applicants. And if my lords, and I hear you, my lords, in terms of the pending determination that is before you, for purposes of today's proceedings, we have 48 applicants. If the first applicant was to be considered for purposes of these proceedings as having withdrawn from the proceedings to await your determination in the other matter, it will not affect the other 47 counties, so that it doesn't embarrass the court. But if the court were willing to hear our submissions on it, I know that matter has already been addressed, so we would still have the 47 counties that are represented by the 47, those 47 governors in the Council of Governors also represent 47 counties. But the state organs are the 47 counties who are the primary parties before you, my lords.
So you are applying for withdrawal of the first applicant?
Yeah, so that we can proceed with the matter with the 47 counties.
Yes.
We can have, because so we don't embarrass your lordships and we don't have to be addressed on whether or not the Council of County Governors. From where I stand, I'm very convinced they are a state organ, but the court will speak on that and we have to await that determination. So we don't want to preempt or to in any way to embarrass the court in its determination on that matter. I believe my friend Mr. Peter Wanyama is the party in that matter, and we are hopeful that the determination will come before the proceedings here started. We saw we were coming to the end of the term. We were hopeful that maybe a determination would have been given maybe last week or something. But that's really within the realm of the court, and we really have no problem with that. We have 48 parties. The chairman is here. We have no problem since he represents the Council of Governors and he also represents the county government. The county government is also before you. So to smoothen the path to the proceedings commencing, for purposes of today's proceedings, then the court can deem we have the 47 counties appearing before you.
Is there an objection from any of the other parties, the withdrawal of Council of Governors from these proceedings?
Please have no objection. Speak to the mic.
Come forward and speak to the mic. Okay.
My Lords, on behalf of the Attorney General, we have no objection to the proposal to go.
I thought you would speak for all the other parties, unless there is a party who has an objection.
If my Lord, on behalf of the Speaker of the National Assembly, we object.
You object?
Yes, and this is formally, and we have time to consider. The Lord should note that the affidavit in support is shown by the Governor of Kakamega in its capacity as the Chair of the Council of County Governors. So if that position is to be taken, then we will be asking for time to reconsider the application.
What is your name, please?
My name is Wendell Lord.
Can you read the entire introduction? Can you read the entire?
My Lord, it indicates
Let's read.
I am the Governor of Kakamega County and the Chairperson of the Council of County Governors, established by Section 19 of the Environmental Relations Act.
So the first and foremost, is introducing himself as the Governor of Kakamega County.
But correct, my Lord.
Yes. And the Kakamega County is a party.
It's a party, my Lord, but he has not indicated, as you will note from the the next paragraph, he has no authority as a governor to swear on behalf of the other counties. That is a position, my lord, is a legal position which you require to consider. That is the basis of our objection. Yes, my lord.
Look at the first one, it says that the signature of the governor.
Yes, my lord. The cover.
The cover.
Yes, my lord.
What I said, the word
Is signed by Honorable Pesa Paranya, Governor, County Government of Kakamega, and Chairperson of the Council of County Governors on behalf of the applicants.
Yeah, so if one applicant goes out, does that affect the rest of the proceedings?
It does, my lord, under the rules of practice, he needs to do more than just declaring here, but say he has authority.
Which rules of practice?
My lord, I don't know whether each county government is distinct. We cannot take that because the county government of Kakamega is signing this affidavit with chief executive. The other county executives have agreed. He was only doing this in our view as the chairman of the Council of County Governors. I know that is our position.
Any other points on your objection? Just see. Yes, now the other parties. The counter is forum. Please tell us why you are here.
May it please the court, Jenga appearing for the County Assembly's Forum. We were parties served with the reference. As you see from the last page of the reference, we were served by the applicants. The County Assembly's Forum is a collective of all the 47 county assemblies. We have described ourselves as such. If you look at our submissions at paragraph 1, and our primary role and our submissions are focused only to the extent of the effect of identified issues on the functions of the county assemblies. So we shall restrict our submissions to Article 186, 185, and 224 of the Constitution that refer directly to the functions of the county assemblies with regard to the budgeting process and how they relate to the issues that have been identified for an advisory opinion on this court.
What will you say that the applicants will say?
One of the things that we shall say and in our submissions is the effect of the impasse on the county government.
Is that not the case for the applicants?
My Lord, if you will allow me.
Yes.
The effect of the impasse on the county budgeting process. The county budgeting process is an exclusive function of the county assemblies. That is Article 224. and Section 8 of the County Governments Act. That is not in the reference. We shall not need more than 10 minutes just to submit on the particular issues that affect county assemblies and the way they relate with Article 203, Article 222, and Article 201 as identified by the applicants.
A society.
Yes, we are a society.
As a society.
Yes, of all the 47 county assemblies.
You say that you're going to introduce new matters into the reference, which are not addressed by the applicants.
No, we are not going to introduce. If you look at the issues as identified,
are your issues outside the reference or they are within the reference?
they are within the reference.
She just asked you what is new that you're going to say, which the applicants won't say.
And that is what, my Lord, if you look at issue number 1, as identified by the applicant.
It's not a trick question.
Yes.
The applicant has an opinion on such a matter. Why are you introducing your own one?
We are not introducing our own matters.
Why are you adding new matters?
We are not adding new matters. We are just commenting on the issues as identified from the perspective of the county assemblies. We have been named.
That is your position.
We have been named at Article 1, at issue number 1 and issue number 3, and we shall restrict our comments on, no, in fact there are only 2. Issue number 1 and issue number 3. We shall not comment on any of the other issues. And those are the ones that relate to the county assemblies.
We have heard you, Mr. Njenga. We will consider whether to retain you or not.
Thank you.
The Katiba Institute.
May it please my lords and my lady, on behalf of Katiba Institute and also the Institute for Social Accountability, TISA, I would wish to state that firstly, we were served by the applicants. Secondly, and perhaps more importantly, is the fact that we have before the High Court a matter in which the petitioner, Wanjiru Gikonyo, has instituted a petition which raises issues that include the issues that will be determined by this court. Ms. Wanjiru Gikonyo is the executive director of the Institute for Social Accountability, TISA. In that matter, Katiba Institute is also a party. Additionally, there is petition number 284 of 2019, which has been brought by the Senate and in which Katiba Institute and TISA are parties. And that also relates to the issues relating to division of revenue within the context of the current bill. My lords and my lady, out of all the parties, whether primary parties or others that are participating in this petition, in this advisory opinion, there is no other party that has addressed an interpretation of Article 203 of the Constitution, nor has any other party addressed the court on the meaning of the judicial phrase, or the phrase that will in my humble submission, become a judicial phrase, revenue raised nationally, what that means. And that's one of the value additions that Katiba Institute and TISA wish to bring into this. In addition, my lords and my lady, it has been the practice of this court to adopt an inclusive approach with regard to advisory opinions. And just by way of recollection, in advisory opinion number 2 of 2013, which directly related to the then Division of Revenue Bill, Katiba Institute was allowed to participate.
So Mr. Nderitu, are you asking us to allow you to address us as amicus, or in what capacity?
My lords and my lady, it's difficult on my feet to distinguish what issues would go to amicus and what issues would go to an interested party. But the truth of the matter is that the question of division of revenue affects each and every citizen of this country. So it's a fait accompli then that we would be an interested party if we are marshalling a position that would be consonant with what any citizen of this country would be raising. But there would be the aspect, for example, with dealing with the phrase revenue raised nationally, which may not directly be an issue that can be expected would be raised by Wanjiku out there, in which event then, with regard to that issue, we may take an amicus position. Having said that, my lords and my lady.
Let me ask, can I ask a question, please? You need to guide us. If you're making an application as an interested party, then you'll be showing us how the issues in this reference could possibly prejudice you. And I think you have taken that direction by explaining that your party is in the High Court.
That's correct, my lady.
If you are raising new issues, that is not something that an interested party can do, but neither can an amicus. So the issue you're talking about of revenue raised nationally is a totally new issue, not brought up by either the applicant or can be done by yourself as an interested party or amicus. So you need to guide us specifically in what capacity are you making this application so that we can be ready.
We would be happy, my lady and my lords, to remain interested parties. Thank you. I just wish to associate myself finally with the submissions that were made by my colleague, Mr. Issa. Thank you.
LSK.
May it please, my lords. When we were served with this application, we felt that we had been served as Law Society of Kenya, because the Law Society of Kenya has a special mandate under the Law Society of Kenya Act to assist the public and the government and this court in the interpretation of law, the Constitution, and any legal law. So we thought that the invitation to us to participate in these proceedings was made in that spirit and was in order.
So in what capacity?
We would like to participate as amicus because we really have no personal interest in the matter. Our work is only to assist the court and the parties and the government and the public in interpretation.
Mr. Kito, had you not been invited or served for that matter, would you have made an application to be enjoined in these proceedings?
We would probably have done so, although I have no instruction at this point in that regard. but we probably have done so because this is a matter of great public interest.
Very well.
Much obliged.
Very well. Are the parties ready to go on before we decide on this?
My Lord Chief Justice, on behalf of the 47 county governments, we are not just ready but very anxious to proceed. We've kept aside everything else in fidelity to the commitment we made last time that we come at 9 ready to be out. Please allow us that opportunity.
Very well. Mr. Mwenda?
Yes, my Lord Chief Justice and the Judges of the Supreme Court, I am ready to proceed on behalf of the Speaker of the National Assembly. And my Lord, there's a matter which I have already brought to the attention of my colleagues, and I've already shared some correspondence with the Deputy Registrar of the Supreme Court relating to the ongoing process of enactment of the Division of Revenue Bill. And my Lord, given the time, I wanted to bring that matter to the attention of the judges, because it's a matter which has a bearing on its reference.
So, Mr. Maraga, what are you telling the court?
My Lord, the effects of the submission I've just made, my Lord, I don't know whether the court has been given copies of some correspondences which I gave to the Deputy Registrar. I have copies here which I can share with the court now. My colleagues have already given the copies.
What would be the effect of the contents of this
correspondence? The effect of the content of the letter, my Lord, is when we appeared before His Lordship the Chief Justice on the 23rd, last week, 23rd of July, my Lord, he implored upon the parties to find a way to have this matter concluded through the constitutional channels which are there. And my Lord, I brought it to the attention of His Lordship the Chief Justice that both the Senate and the National Assembly had republished the Division of Revenue Bill separately. My Lord, the input of the letters I've just shared is one is from the Senate dated 23rd July 2019, and the other one is from the National Assembly dated 26th July 2019. My Lord, in the two letters, these are messages from the two speakers conveyed through the respective clerks of the houses, that each of the houses have considered the Division of Revenue Bill, and they were now exchanging the bills in accordance with Article 112 of the Constitution for further consideration by the two houses so that they can conclude this matter. My Lord, my humble submission and request to your Lordship is that, my Lord, if this matter is properly before an arm of government, an organ, which is the legislation. And a lot of things, when you look at there's a new...
Has there been mediation?
There is no mediation, my Lord, because we have not reached there. And Article 112 of the Constitution, my Lord, perhaps you could have a look at it. The provision is that once the houses have received the message from the other, they consider that bill afresh. They consider the estimates, they consider the input in the bill. Then they convey the same message. If they are not able to agree on what is contained on the bills, then when we now move to operationalize Article 113 on a mediation committee.
That we have read and we understand very well.
Yes.
So that's why I'm asking you, has there been that mediation?
There is no mediation, my Lord, because each of the army invoked by my client, but the National Assembly, when it received this message from the Senate, in accordance with the standing orders, it conveyed this message to the relevant committee on budget and appropriation. The Senate, my Lord, I would assume it has done the same. So that, my Lord, the process is ongoing. My Lord, you recall your decision in the first advisory relating to the Senate and National Assembly, is that you urge the the respective speakers to find a way to ensure the stalemate moves forward and to contribute matters amicably to resolve any dispute arising in a matter of this nature. My Lord, your decision, Justice Kairuki Martin, I think there is a specific finding where the Supreme Court said if a matter is specifically before a state organ with constitutional mandate to deal with it, then the court will exercise restraint. And when you look at all your decisions in the previous advisory...
Mr. Mwenda,
yes.
You are now going into arguments.
No, my Lord.
Wait a minute. We are now going into arguments. We asked you whether you are ready and you said you are ready, but they want to point out to the court that there is a process which has not been completed.
Correct, my Lord.
Stop there now. If you have pointed that out, let's hear from the other side. Let's hear from the other side. Mr. Ngatia?
Thank you, my Lord.
My Lord, National Assembly is being quite unfair to this court and to the county governments. In paragraph 27 of the affidavit, they say they published the bill, Division of Revenue Bill, in March this year, based on their own figures. Senate rejected it. A stalemate ensued, and in terms of Article 113, a so-called mediation between the two speakers did not even achieve anything, and the bill was defeated.
No, Mr. Kagame, make it clear. What Mr. Mwenda is saying is that the mediation committee is there one in the first place.
That's the point I'm trying to explain to my Lord.
Yes.
With the first bill that was done in March, it went to a mediation. It failed. Having failed, in compliance with Article 113, again, National Assembly published a second bill. This time, Senate also published their own bill. And in those two bills, what they are differing about are shillings and cents. There is no mediation which can prevent the hearing of this matter, because in both, they are arguing about shillings and cents. The reference before you, my Lord, deals with constitutional issues. And those constitutional issues are fit for the hearing by this court. And my Lord, please do not tell Mr. Mwenda is being very, very unfair, saying that there is any mediation. Sorry, Your Lady.
No, continue.
The process really is the process that will defeat devolution. Let me explain this.
No, Mr. Ngatia.
Yes.
We are at one point.
Correct.
Whether or not there has been a mediation process carried out as required by Article 113.
Yes. The direct answer is this. With the bill that was published in March this year, which is really the primary bill, there was a mediation process and it failed.
Mr. Ngatia, Mr. Mwenda, you are saying there was no mediation process. Mr. Ngatia says there was. What is the position?
I don't know if you allow me, Honorable Governor.
The judge was to ask me a question before.
Let Mr. Kalma.
Very well.
Yes, well, the position being conveyed by Mr. Mwenda on our behalf is that the division of revenue bill, which is the basis of the reference before you, was transacted, it went to mediation, the two houses disagreed, and in law it is lost. What Mr. Mwenda then is saying is that following appearance before you, the House of Senate originated a new division of revenue, which they debated, they transacted in the third reading, and they have approved. And in law, the letter that has been placed before you is the letter from the Senate conveying their determination on that republished division of revenue bill to the National Assembly, also to consider and decide. The National Assembly, on its part, by way of seeking solution, also republished a division of revenue bill, the previous one having been lost. And that has been vetted to the third reading, passed and approved by the National Assembly. The letter you see from the National Assembly to the Senate is in line with Article 110, conveying to the Senate, recognizing that both houses need to participate on the matter. That the National Assembly has also transacted that bill. Do also consider it. What happens thereafter, is that the houses have some limited time. I imagine 7 days or so, within which to transact the respective bills from the two houses. If they agree, the matter will end there. And I imagine in the context of this matter, in this case before, if the two houses don't agree to pass the respective bills from the two houses, then there will be a mediation committee. So, Lord Chief Justice, the mediation your Lordship is asking about will come later. Will come later. After the 7 days, after the respective houses are transacted, the bills coming from state and the houses.
That is on the republished.
Yes, the republished division.
Yes.
And Lord, let me clarify that we've looked at the pleadings before you. This matter is not constitutional. It is likely quantum.
Don't go into that. Don't go into that. No. We will give you time to go into that if we just want to clarify that the position of mediation.
Yes.
Yes.
So mediation will come possibly after the two houses have transacted the respective bills.
Honorable Kanuma.
Yes.
These exchanges, what time limits are provided for? When are they? We talked about 7 days. What time are required?
It should be either house should transact within 7 days.
Are there specific standing orders or rules to that effect? Because it's important.
It should be the standing orders.
Okay. Then after the exchange and the lapse of the 7 days or whatever time, when is it deemed, and or what is the signal that you have failed to agree and the matter must go to mediation committee? And if it's going to the mediation committee, what is the time frame required?
Again 30 days. Defined in law. 7 days to each house to consider. Lord, I'm being referred to Article 112, Sub-Article 2A, and Article 113, Sub-Article 4. 112 says that if after the originating house has reconsidered the bill referred back to it under clause 1B, that house passes the bill as amended, the Speaker of that house shall refer the bill to the President within 7 days. And then 113.4 says if the mediation committee fails to agree on a version of the bill within 30 days, so the mediation has to be within 30 days. So it is 7, then 30. I presume the two houses of Parliament are proceeding in good faith in seeking a solution to the matter.
Just a minute late, I want Mwendo to complete his submissions. We record before we go to the other side. So, Mr. Mwendo, what you are saying, you are ready to proceed, but the process has not been completed before the two houses. So, what do you want from us?
My Lord, what then we will be seeking on behalf of the Speaker of the National Assembly is my Lord, it will be good practice and in the interest of justice, obedience to the Constitution, to allow the two houses to reconsider this matter. My Lord, once bills have been republished, because the previous ones were deleted, this is a fresh matter. My Lord, you do not. Particularly the fingers in the two bills are different from the fingers which were exhibited by the applicants, showing these are fresh matters. Which if it was a new matter, perhaps we would raise that the previous one is already overtaken by them. My Lord, if you then indulge us, grant us time, now the House to consider these matters. There are timelines which are constitutional.
How much time?
My Lord, on my side, I would ask for 45 days for the following reasons. Mediation will take 30 days. That is constitutional as for 113. My Lord, we don't know as we stand here how long each of the houses will take under Article 112 before they submit the bill to do a message to the other house, so that now we can initiate mediation. If at all there will be mediation, this matter may be resolved under Article 112, my Lord. In which case, my Lord, when you look at the issues raised, there will be no issue for determination for now. Thank you.
So in the interim,
my Lord, I can ask the court can adjourn this matter up to a time which it can direct, or it change this matter for us to take fresh dates if there is no contribution from the ongoing consideration.
yes, Counsel for the Senate.
My Lord, what the National Assembly is telling you this morning, that we are back where we were in June, and they're asking us to continue this process, which has failed. Secondly, my Lord, that discussion that the houses are having is on quantum. This reference goes beyond the issues of quantum. We want you to guide both houses on Article 260. What is the status of the recommendations from CRA? We also want you to...
That Ms. Tantu we will handle.
Yeah.
We want to know that the matters before us, the organs of state are exhausted what they are required to do under the Constitution, so that we know how to deal with the matter.
My Lord, the Senate's position is we have exhausted, and we are now in the unprecedented position where we have two division of revenue bills. That already tells you there's a problem, and it also tells you that we are back where we were in June.
Was there mediation, according to you, of the first proposal? The first proposals.
The first proposal went to mediation, and
yes.
This second proposal.
As this, as the second, the first proposal, the first bill, as it were, lapsed.
Yes, it's repeated under 113.4.
Yes.
And now what has happened is both houses have published a bill clinging to the same amount that were defeated the first time. We have not moved an inch from where we were in June. So what the National Assembly is saying is give us more time to disagree.
Can I ask you a question? You're saying there are two division of revenue bills, but actually there's only one. The other was defeated.
No. It says that the National Assembly has published division of the revenue bill 2019 with 316 billion. The Senate has also published a division of revenue bill.
No, that's true. Let's do this slowly. Perhaps because I used to be a member of Parliament, I'm trying to see whether it has changed. Can you have two bills on the same issue at the same time?
That is correct.
Or do you have one bill, if defeated, after some time, a new one comes to the floor of houses? And if so, as Senate, because you're speaking as Senate, how is Senate dealing with two different bills, or is Senate dealing with the bill which is currently under discussion? Which is it?
My name is the first bill failed. The first bill that went to mediation failed. After that, it went to mediation and mediation failed completely. That bill is defeated under 134. Then thereafter, we now have the Senate has published their own bill with the amount of 335, which they have debated and passed, and forwarded to the National Assembly, and it was introduced to the National Assembly.
Yes, so at the stage where we are at the stage where we are, is it possible to resurrect the first bill?
No. So that's precisely why we are asking this court that we are back where we were in June.
Under 113.4,
yes.
the bill that was defeated no longer exists.
Yeah.
What the National Assembly is saying, we now have a new bill under 112.
Yes.
And so we are saying, necessarily when following the Constitution, you must go through 113. answer the question.
Not
Has this one been fixed?
No, this one is.
So 113.4 has not kicked in.
That is true.
And they are saying, before 113.4 kicks in, 113.1 to 3 must take place.
That is true.
What is so difficult to that?
Our difficulty is
Just a minute, if I may add another question, so that you can answer both. That is on the part of the National Assembly. But on the part of your client, the Senate, by this letter of 23rd July, you have stated, you have referred this, the Division of Revenue Bill, Senate Bills number 13 of 2019, to the clerk of the National Assembly, whereby you have referred to Article 110, Article 4 of the Constitution, and you have forwarded to you the message from the Speaker of the Senate seeking concurrence of the National Assembly to the bill. So you have forwarded your own bill to them in the last 7 days. And you are waiting an answer from them. After which it fails, you must go for another mediation on these two bills.
Thank you, my Lord. That now brings us to 163.6. There is a reason why the Constitution gave the Supreme Court power to hear matters affecting the county government, because in this current position, Parliament cannot agree, but the people who've been shut down are the counties, and that is why 163.6 has kicked in. Yes.
What is stability under 113?
My Lord,
because 113 must be exhausted. 166 to kick in.
Because
right now, we have not hit 113.4. And that's what the National Assembly said. So we are saying, we are making this submission that they are failed to agree, and yet we just agree with us. The second bill, this one is again sent to CRI, has not failed as 113.4. Lord, we are told us this question. Is it proper to wait for 113.4 to kick in, whatever period that the money is asking for, and then at that point, before a bill at large is out there, then you can come here. That's what the National Assembly said. And we're not asking a question, you're saying, ignore 113, go to 163.
My Lord, I'm not saying ignore 113. I'm saying what 113 will solve is the question of quantum.
Right.
Why can we not agree? It is because we cannot agree on 216, on 218, 224. That is why the applicants are now before you this morning.
So that you're saying,
yes,
we don't want 13 questions, yes, which you agree yourself is premature.
Yes.
Would you agree that I agree premature? Yes. There are other issues in the reference, yes, which require hearing because they are not under 113. Okay. That is your submission. Yes. And you understand it better.
Yes, and my submission.
Therefore, you're saying, leave 113 alone.
Yes.
Proceed with 216. Yes. Proceed with 203. Proceed with 218. 202. 202. That's what you're saying.
Yes. I'm also saying that if your decision in the interim independent electoral commission, public importance, the urgency of this matter, public interest, those are also factors that you should consider when your jurisdiction is involved.
But you believe that 113 is the most urgent matter here?
Yes,
others can wait.
They cannot wait, my Lord, because look at the applicant submission. We fight over this division of revenue every year. Division of revenue 2016 is still in mediation. Yes.
Just a question though. You know, fidelity to the Constitution is very important. Are you suggesting or inviting the Supreme Court to intervene in a process where there is an ongoing legislative process that is not completed and which may be affected by whatever intervention you make? Are you inviting the Supreme Court into the chamber of the legislature?
That is not what they invited, because the jurisdiction under 163.6, if it's fidelity to the Constitution, it is to look at what is the threat to the counties and the threat to the population. The threat currently is that Parliament cannot agree. Now, the issue of quantum, we also are not asking this court to set quantum. That is what the housing will be. What we are asking the court is to consider the other factors under Chapter 4 and the other the devolution Chapter 2
That is where the problem. First, what triggered these proceedings? What triggered this? What brought the government here? Was it not the collapse of the division of revenue? Okay. And then these other questions which you're saying this court can pronounce itself over. Do you really expect this court to give an advisory opinion about these other questions without resolving the impasse over the division of revenue bill?
Yes.
How will that advisory opinion be useful to what is now facing this country or the counties?
My Lord, this court is the apex court.
It is, of course.
Yes.
That is why we are asking if you say that now we should disregard the division of revenue bill or the impasse thereof, and then go answering these other questions, which questions derive from exactly that impasse? Do you expect this court to give a comprehensive advisory opinion without dealing with the now failed division of revenue bill?
And if you look at the reference before you this morning, the government, the county governments have highlighted the difficulties that arise from 202 to stay highlighted that this is a problem that has been recurring. This is a problem that needs addressing, and this is the only court that can settle on how the constitution should be applied. That's why we are praying for the court to intervene at this point.
This court will definitely intervene. That's why we are here. We are already intervening. This is a form of intervention. We want to have a structured intervention that respects the architecture of the Constitution. Okay? Because being the apex court, whatever it is we say will have an impact on even how these two houses relate now and in the future. That's what we say. So we just wanted to understand how now you want us to discard what you are now terming questions of quantum. But it precisely is the question of quantum that triggered these proceedings.
My Lord, it's not just quantum, and the reason why 166 is specific on county government is because they are at the mercy of Parliament, but they do not have control over that process. That is why we have moved the court.
Okay, Mr. Ngatia and the other parties, let's hear your views.
With your permission, my Lord Chief Justice, I think we are taking a trajectory that could be quite unfair to us. Allow me to say this, my lords. There was a bill that emanated or originated from National Assembly, as it should. That bill was rejected by Senate in June this year. A mediation took place. From that mediation, there was total failure. Please, if you just allow me this, from that failure, actually the problem was escalated. Instead of a bill again originating from National Assembly, as Lady Justice was asking during her time in National Assembly, this time both speakers are chest stamping to each other. Each originates their own bill. They are chest stamping. By each originating their own bill tells you that we are now in very unfamiliar territory. Because you can't have a mediation of two bulls that are locked. Each and I think, my lord, you have seen my point. Now, with each chest stamping on the other, even the so-called mediation, and I'll put this very, very bluntly, is actually an exercise in futility. Chief Justice, you asked a very pointed question. National Assembly lawyers run away from it. In the interim, national government is appropriating its revenue for its business. In the interim, county governments have nothing. So county governments really are at your mercy. If you'd allow this circle to go on and go on, another again, another bill will both bills again will originate, because these are speakers who are next to each other. Instead of even going to discuss quantum, and my Lord, Judge of the Supreme Court, we are not dealing with quantum. We are actually dealing with the principles in the Constitution. Instead of these two gentlemen just sitting across each other, what they do is do that which I do not want to repeat again. Originate mine, originate yours. Throw it to the other and throw it to the other. 113 kicks in, mediation again fails. My lords, devolution is in your hands. You could tell us, go on with the circle ad infinitum. We'll go on. In the process, these counties will grind to a halt. I speak on behalf of each of the governors who has come here, because that is where they are going. The process is a process into nothing. The two speakers cannot have a mediation. Mediation, as we understand it as lawyers, would be, for example, inviting a third party to sit with us. But the mediation in this legislative process is amongst the same two houses who are chest thumping at each other. Please do not allow this country to go that way.
Mr. Ngate, we previously, in the previous advisory opinion, suggested that there should be a standing mediation committee between the two houses.
Yes.
Was one formed?
No, it was like many things that come from the wisdom from this house to the two speakers, they don't even think twice about it. There's nothing like that.
So if you were to go to mediation, they have to set up a mediation committee.
It's just the two of them.
Yeah.
Yeah.
Very well.
Yes.
Yes, it's just the two of them, but that's what the Constitution says.
Correct.
I hope you're not suggesting that we should go outside the Constitution.
No, far from it. All that I'm saying is this. This process was triggered by the defeated bill. Having been triggered by the defeated bill, can these other simulations be a barrier or an impediment to a constitutional process? Because we have also, so to speak, invoked a constitutional adjudication process. Can a simulation be the one to be an impediment to our day in court?
What do you mean by that, assimilation?
Assimilation.
Because here we talk about a legislative process which is ongoing. That's my understanding. So I don't understand the term.
If Mheshimiwa could just hold his horses. I said a moment ago, the bill went through the process, the 113 process, 112 and 113. It was defeated. What I say is now assimilation is this.
Can I ask you a question?
Yes.
Sorry. Can you answer the questions I put to, was it to Mr. Mwendo? Was it the questions I put to Mr. Mwendo when I read this? Yeah. You want me to repeat?
I think so, Judge.
At the moment, on the ground, in Parliament, in the two chambers, in the two institutions, legislative institutions, each one has passed their bills. The National Assembly, after the bills that failed, right?
Yes.
That's the understanding. So, and that's the issue you're calling chest thumping. National Assembly have passed and sent their bill to the Senate. Senate, which represents and stands for your clients, have generated their own division of revenue bill. This is a fact. They have gone through a legislative process. They have done actually a legislative process under the Constitution. So it's really surprising that you can call that chest thumping and simulations. Particularly this term you said simulations. Because for me, it's a constitutional process which has taken place. And let's take this letter seriously. From your Senate itself, they have forwarded the bill, seeking concurrence of the National Assembly to the bill, with all the votes and proceedings and the Hansard and the other papers of the sitting of the day. On not so far away, 27th July. Yeah? Today is 31st, right? Yeah. So about a week ago. Yeah. So where do we go from here? Because we cannot just wish this document, this process away. So we must know as a court what is the effect of this constitutionally.
I think, my Lord, if you allow me to answer, it's a question of weighing one against the other, whatever word one deploys. You have a stalemate in the two houses. You have the process which ended up with the defeat of the bill. Then the more pertinent question is this. Senate has no mandate to originate the bill. The bill ought to originate in National Assembly. When one is... There's quite a bit of interruption. The bill ought to have originated from National Assembly. After the legislative process, it is sent to Senate. This time, two bills are being debated at the same time. And this is the kind of question, my lords, I'm saying. Please understand that it's a process that can continue on and on and on. Yes.
You're telling us, although these bills are said to come under one form, ignore the bill, ignore the person 113, consider making your decision. How would you say this? Is it not?
I am saying there's a crisis.
Now we understand, but I'm saying, 113, have a procedure. And you're telling us that you know that procedure, you go 163.6, make your opinion, ignore all this. That's all I'm asking. This is what you're telling us to do.
As a matter of fact, the time that we have we've been engaged in this, if you had allowed me to actually argue this matter, I would have demonstrated that the procedure, yes, I'm answering you, that the procedure connecting these two bills is unconstitutional. Because the foundation of both bills is not the Constitution, if you had allowed me. So, as a matter of fact, standing where I am, both bills are based on unconstitutional invalidity. And that will be the question that I'll be posing to this court.
Let's see at the AG.
Lord, the AG here will speak as amicus to assist the court. The position of the AG is that we support an amicable resolution of this matter. It is a matter of great public interest and public importance. We are aware that the law has structured the timelines within which this matter is to be concluded, but it is within the power of these two institutions to actually conclude this within even 20 days or 25 days. They don't have to stick to the 30 days deadline that has been set. In this case, just on a light note, my brother senior is saying that there are two bulls fighting. And now the court is being asked to be the bigger bull here. I am not sure that that's a position that you want to assent to, but we must give that process of amicable resolution of this matter a chance, because that is within the constitutional design.
Timelines are set in which act?
Pardon, madam?
The timelines are set in the...
There is a 30 days timeline.
The 30 days timeline in the Constitution.
Yes. So they can do it within a shorter time than that, because within their power, and if they can generate sufficient goodwill between themselves, this can be resolved, so that then we bring closure to this very delicate matter.
Are you suggesting any shorter time?
No, I can't suggest for them, but I'm urging that they can do this within a shorter time.
Okay, very well.
Okay. Mr. Nyaoga, before you...
Yes, madam.
You've had the submissions by Mr. Gatia and Mr. Tanya.
Yes.
And we are really telling this court that from the history of how these two houses have been elected over such a matter, they see no possibility of a resolution. And as the attorney general, because you usually join this court in an effort to safeguard the authority of the Constitution. In fact, to make sure that the Constitution is adhered to by every individual and stakeholder. If, in fact, this process turns into a circus, you would not expect this court to give you any other opportunity to plead for the need to exhaust the procedures in the Constitution. You wouldn't expect this court to accord you that indulgence.
Yes, madam.
You wouldn't.
I mean, if there are a number of factors to be considered here, madam. I think the first question is whether this matter then will belong appropriately to this court or belong elsewhere. Because those are questions to be determined, because this court has made findings on which matters belong here. The Secretary for matters to fall within the jurisdiction of this court. So that decision has been made by this court to start with. But again, where we are now, we can only be hugely speculative, because if this process is given a chance, the character of this matter might change. We may have issues arising. For example, as Parliament acted constitutionally, and if that's the question that is going to be framed arising from this process, that might belong to a constitutional court. So at the moment, I am not sure whether I want to engage in a little speculation in this, because the character of this matter might change depending on how this matter matures as we go forward.
But there is a real stalwart, and you have the government that says that counties are really, they're not operating. That's as the attorney general.
My Lord, the matter is very concerning. I started by submitting that this is a matter of grave and great public importance, and that the Attorney General supports a process of amicable resolution of this matter. So that's the first point. So it's very concerning. It's a very delicate matter, and really the two houses ought to resolve this matter, because it is affecting a lot of people going forward.
So Mr. Nyauga, you would rather we leave the two houses to take their sweet time?
No.
And resolve the matter?
No, my Lord. I did say that there are constitutional timelines that have been set, or legal timelines. They don't have to stick to it, because in fact, they have no leeway or opportunity of taking their sweet time, because the law has set limits. Their guidelines, their boundaries have been set by the law. So they cannot even afford to take their sweet time. And our position is that they ought to resolve this in a very expedited manner.
Thank you. Who is for appearing for the CRA?
May it please my Lord, the Chief Justice, my Lords and my Lady. The truth of the matter is that the court's perspective on the timelines and the need for negotiations under 112.113 are correct. But I think as the court eventually retires to consider this matter, we must recognize the context in which the Constitution, the constitutional provisions exist. They assume rationality and reasonability and a purpose. My Lords, the timeline set on the publication of the DORA, Division of Revenue Bill, by the Constitution is 2 months before the end of the financial year. That is there for a purpose, so that that process is completed before the end of the financial year. In fact, the Public Finance Management Act pushes it further back to February to allow more time. My lords, we are now in July. We're now in August. We're now in August. The Division of Revenue Bill has not been passed. Now, the National Assembly, indeed even the Senate, the national government has the luxury of an extended time of mediation because they have appropriated their budgets. They are spending. The context which we find ourselves in is that the county governments are unable to appropriate, they are unable to spend. We are now in July. My lords, that calls for a crisis management. The reason why the COG, the applicants came here with whom we associate, is because as a last resort, we have a crisis. And to allow this process again to go through another mediation in that manner, that mediation was intended to be there for a purpose. That purpose has been defeated so far, and there are serious prejudices to the county governments. My lords, the point that has been made by my learned senior, Mr. Ngatia, is correct. If there was appetite for mediation, there would have been no need for the houses to publish two different bills. That should tell the court that we have a major crisis beyond what the Constitution anticipates. And the responsibility, my lords, and the reason why we come to this court is when such a situation arises, the only other person who can resolve this sort of situation is this court. If we leave it to the parties, we will be back here in another 45 days, and maybe another third bill will have been published, and will be undergoing similar mediation. But the prejudice, not to governors, to county governments, and the citizens of this country will be immense. And so, my lords, we come here recognizing that these are not straightforward fact and provision questions. These are deal with fundamental principles which will help unlock this perennial process. And if the court can help us do that, it will have done a great service, not just for county governments, but even for the national government with a level of certainty. So, my lords, my lady, that's why we come here, to ask what is the purpose of these provisions and how do we ensure that these processes achieve their objects and achieve their purposes. How do we achieve the ends of Article 219 that requires that the money due to county governments is released constitutionally very early, but there's no money to be released. So we're saying, my lords, that it is important that we don't forget the context in which these issues have arisen. Much obliged.
Your submission is that we proceed immediately.
My submission, my lord, will be that we proceed because this is the only forum in which this process can be resolved.
So we proceed immediately.
My lord, that will be our submission.
My lord, just one clarification on the time limits. The time limits.
Sorry, Mr.
Abdikadir, my lord, for the applicant.
You are for
the applicant, my lord.
Just a minute, we are coming to that. We are coming to that. We have the control of budget. Was he represented? No. Okay. Okay, Mr.
Yes, sir. My lord, the perception of the court is that the 30 days is for resolution. It is not. The timelines for the mediation between the houses is for the committees to report back. It does not mean that the matter will be resolved. That is exactly how the other one failed. So the perception that the mediation, and the mediation is assumed to be one mediation, my lord. The presumption in the process is that the two houses will conflict, there will be a mediation process, that mediation will unlock the process and the process moves forward. Because it's a budget process, it's a 1 year timeline from end to end. And we're into the third month of the budget year. And this process could start, and the mediation committee could report back to say we are unable to agree 45 days from now. That's number one, my lord. Number two, really, my lord, Mr. Lenola, Judge Lenola, it's an abuse of the constitutional process. What is before the National Assembly is not the constitutional process. It's an abuse of that process. Because the national government is functioning, has appropriated, unconstitutionally, if you ask me, they have the luxury of time to take the counties through this rigmarole. While the counties cannot budget per constitution without the Division of Revenue Bill Act, without the County Allocation of Revenue Act, after which their budget process starts. So because of that slippery slope, we are in a situation where the National Assembly
can abuse the constitutional process, can abuse the constitutional process set out in 113, while these are the processes. So there's a breach of there's a constitutional crisis going on, and while the court, in a reasonable process, is very much within its ground to say, why don't you exhaust those other processes? We are not in that situation, my Lord.